हेलो फ्रेंड्स, स्वागत है वंस अगेन यहाँ पे। तो इम्पोर्टेंट अपडेट फॉर द फ्रॉम द बैंक पेंशनर्स पॉइंट ऑफ व्यू। सो उसको यहाँ पे डिस्कस करेंगे फ्रेंड्स अमंग ऑल ऑफ यू। सो यहाँ पे आप देख सकते हैं इन द हाई कोर्ट ऑफ ज्यूरिडिक्शन एट बॉम्बे नागपुर बेंच रिट पिटीशन। यहाँ पे सर्च कर सकते हैं दोस्तों आप 2539/21। और जो केस है रिटायर्ड वर्सेस द यूनियन बैंक ऑफ इंडिया द यूनियन ऑफ इंडिया through its secretary, Ministry of Personal Public Grievances and Pension Department, New Delhi. The Division Bench of Justice A.S. Chandrukar and Justice Brushli V. Joshi observed that no departmental proceedings were held against the petitioner prior to his superannuation, based on which he could be deprived of his pensionary benefit. The impugned communication also does not speak of the depriving the petitioner to such retirement benefits. So, thus, as the petitioner has superannuated without being placed on supernumerary posts, there is no reason to withhold his pensionary benefits. Advocate Rashi A. Deshpande ji appeared for the petitioner, where Advocate Anshuli Deshmukh appeared for the respondent. The brief facts of the case were that the petitioner has superannuated as deputy manager scale 2 on the very day a notice was issued calling upon him to show cause as to why departmental action should not be initiated against him under the United India Insurance Company Conduct, Discipline and Appeal Rule 2014 for not submitting the caste validity certificate. This lapse omission, according to the respondent, constitutes misconduct. So, after considering the submission, the bench referred to the decision of the Apex Court in the case of Union of India KV Jan Kiraman to note that only show cause notice is issued in the present case on the date of retirement and calling upon the petitioner to explain why departmental action should not be initiated for failure to submit the validity certificate. So therefore the mere issuance of such show cause notice would not amount to initiation of the departmental inquiry, added the bench. The bench found from the pursuit of Rule 45 of the pension scheme that the gratuity and pensioner benefits can be withheld only if the departmental or judicial proceedings are instituted against the said person on the date of his retirement. So, finding that the petitioner was promoted from time to time and thereafter superannuated, and there was no disciplinary inquiry initiated against him while in service. So, the bench held that the question of payment of provisional pension and withholding of the benefit does not arise. So it is not the case of the respondents that at the time of entry in service the petitioner played any fraud or obtained a certificate by playing fraud, added the bench.